Good afternoon, everybody, and welcome to this lecture. So the program for today is that we're going to begin by summarizing the fifth lecture, and then we'll have an opportunity to discuss any issues arising out of the summary or from the lecture generally. So if you already have any comments that you would like to make on our last lecture, or if you have any questions, either now or at the end of the summary, then please do post them on the chat. Then we're going to discuss or conclude our discussion on external stakeholders, and then we are going to turn to the funding of multilateral institutions. So that's the program for today. So turning first to the fifth lecture. So we saw there, in the context of considering governance at international financial institutions, that one institution worth considering in some detail is the AIIB, to look at the governance at the AIIB in some detail. And the reason for looking at the AIIB is that when learning about governance, the AIIB is an instructive example because it's the most recent of the large IFIs. And so some of its governance elements represent continuity of the practice of IFIs generally, and some elements represent a departure from that practice. In our lecture, we noted that the AIIB Charter contains a number of provisions that underscore the modern nature of its governance, some elements of which may be seen as innovations. So as at EBRD, AIIB directors may split their votes to reflect differing views within the constituency they represent. And as at EFAD, AIIB has a non-resident board. As at several other IFIs, AIIB distributes a significant number of its shares evenly across all members, irrespective of their economic strength. In addition, some elements of the Charter dealing with governance are unique to AIIB. The Board of Governors is authorized to amend the Charter without referring back to the members, where ordinarily parliamentary and similar approvals would be required. The Board of Directors is empowered to delegate project approval authority to the President, something it has now done. While oversight mechanisms at other IFIs have developed through practice while oversight mechanisms at other IFIs have developed through practice, at the AIIB, such a mechanism is elevated to the level of and entrenched in the Charter, with the board, for example, having reporting to it an independent unit that handles procurement and project-related complaints, as well as the evaluation of projects, so that lessons from them may be learned. Another innovation in the Charter is that the AIIB president is to be elected through an open, transparent, and merit-based process. On this, the Board of Governors has adopted election rules that reflect this requirement, and which, uniquely for the larger IFIs, is publicly available. In the lecture, in our discussion of governance, we noted too that the AIIB Charter is accompanied by a report of those who negotiated it, an approach that has its precedent in EBRD practice. In noting that these documents may be helpful in applying the Charter, we discussed the basis on which treaties, such as the constituent documents of the IFIs, are interpreted. Here, we returned to the Vienna Convention on the Law of Treaties, whose prescribed rules on interpretation are essentially reflective of customary international law, which binds international organizations even though they are not party to the Vienna Convention itself. Here, the primary rule of interpretation, is that treaties, such as the Charter of IFIs, must be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. A good faith interpretation, we noted, implies that reference will be made to the reports of the chief negotiators where relevant. Having concluded our discussion on governance, we then turned in the fifth lecture to the subject of internal administration. Here, we began by considering the role and place of the three governance bodies of IFIs. We observed that individual governors are remote from internal administration, even though when acting collectively as a board, some of the most important decisions of the organization fall to them. This remoteness, combined with their obligations being owed entirely to the member appointing them, is underscored by the absence of any institutional code of conduct applying to the governors. By contrast, directors are bound by a code of conduct, but the codes of IFIs recognize that directors have dual loyalties, one to the institution and one to the members they represent. Of the third governance body, namely the president, loyalty is to the institution alone, as reflected in the applicable code. This exclusive loyalty is critical to the independence not only of the president, but of the staff, given that they report to him. This exclusive loyalty and the applicability of a code of conduct are also hallmarks of the staff of IFIs who have the status of international civil servants. A number of consequences flow from this. In particular, matters such as the hiring and supervision of IFI staff, the setting of compensation, and all the attendant administration is regulated by the institution itself and not the law of the host country of the institution or any other domestic law. Where staff grievances arise, these are to be resolved applying the processes put in place by the institution and not by recourse to domestic tribunals. Moreover, the law to be applied is not any domestic law, but the law of the International Civil Service. The employment contracts of IFI staff are governed by their letter of appointment, the internal law of the institution, such as the Code of Conduct, and in particular staff rules issued by the President, and thirdly, generally accepted principles of international administrative law, being the principles distilled from the jurisprudence of the administrative tribunals of international organizations. Finally, in our fifth lecture, we began considering the relationship between the IFIs and those external to the institution. That is, those having a relationship with the institution beyond the people who make up its governance bodies or comprise its staff. We identified several categories of such external stakeholders, noting that in many, but not all, instances, their relationship with the institution was defined by contract. The exceptions were regulators and third parties affected by the institution's activities. We noted that where the relationship involving the IFI is contractual, then all the usual considerations relevant to contracts generally will apply. So, for example, where an IFI procures furniture for its headquarters or hires a law firm to advise on a transaction, the contract will address the nature of the goods or services to be supplied, the terms of payment, and so forth. However, contracts with IFIs will also need to take into account the special status, exemptions, privileges, and immunities of international organizations that we have already discussed. In the two examples just given, the contracts would need to ensure, for instance, that VAT or goods and services taxes are not included in the price of the goods or service, as the IFI is exempted by its members from paying these. Two related issues that frequently arise in the context of contracts with IFIs include the law that governs them and the means of resolving disputes. These two issues will be addressed first in the sixth lecture. So the two big issues that we are going to address in relation to the contracts between the international financial institutions and the external stakeholders are governing law and dispute resolution. So again, by external stakeholders, we mean those parties, those persons, those companies, those members that the institution has a legal relationship with, either one that it's set out to have or one that's thrust upon it, but which excludes those parties that are associated with the internal administration of the institution. That is to say, the personnel who people the three governance bodies, the Board of Governors, Board of Directors, and the President, as well as all of the staff. So the nature of the governing law and dispute resolution factors is a function to a significant extent on the nature of the underlying contract, and also to some extent the nature of the counterparty. So let's address governing law first and turn to dispute resolution a little bit later. So if we begin with procurement contracts, so international financial institutions need to procure a whole host of goods and services. So they need to have IT equipment, they need to have furniture in the office, they need to have the stationery for the staff to use, all of these things. So they all need to be purchased. And it's in the nature of these things that often, especially in relation to physical assets being acquired, that these are provided locally. So that's certainly the case with IFIs that are headquartered in very large countries. So if you look at institutions headquartered in Washington or in Beijing, then a lot of this kind of procurement is very local. And it's very common to have the local law regulate the relationship between the contractor or supplier and the institution. So there's no requirement that this be the case. And indeed, from the perspective of the international financial institution, they would sometimes prefer to have a different law applying, particularly if the law that is provided locally is one that is not very developed in relation to procurement, or if it's not very accessible, or if it's not very stable. But the reality is that there's usually very limited negotiating power. So if you are an international financial institution and purchasing some stationery, then there won't be very many choices about the governing law. And in fact, the counterparties that you're engaging with probably often won't have the level of sophistication necessary to address these issues. So the idea of purchasing your stationery and having some external law apply, a law different from the domestic law, is something that will strike the supplier of the stationery as being very odd. And maybe ultimately this could be resolved, but it will take a lot of time, and there is not that much at risk for the institution relative to the benefits of delivering the goods and services quickly. So in the case of procurement then, it is usually the national law that applies. In the case of in the case of personnel relations, then we've already seen that in relation to staff in particular, they are members of the International Civil Service, and they have their own governing law for those contracts, in particular, or specifically rather, the appointment letter. They have the internal law of the institution, such as the Code of Conduct and staff directives, and generally accepted principles of international law. But the staff are not part of the external stakeholders. However, many institutions have people who are working in the institution and who have a relationship that is somewhat akin to staff, but they are not staff. So they are, for example, consultants or secondees from other institutions or interns coming to work over a summer. So in a way, these are external stakeholders, and the law that has to be applied to their contracts has to be determined, and it will usually be specified either directly or indirectly in their contract. So here there are a lot of choices on the applicable law, but it's also the case that in some instances the law is not specified in the contract or cannot be implied by reference into the contract. And so the no contract is governed by something other than law. There's always some law, even if it's not clear which law it is. But sometimes there is this uncertainty, and the institutions are happy to abide by it. And the practical reason for that is that the institutions are very familiar with the law that applies to the staff, and in particular, the internal law of the institution, and to a lesser extent, generally accepted principles of the International Civil Service. Although the legal department will know those things very well. So the people who are administering these contracts, they understand the law that applies to the staff. They won't understand the labor law of Japan or of the United States or of the United Kingdom or of China. And therefore, they won't be very keen on specifying that as the governing law. So I would say if you look at consultancy contracts, in many instances, they simply won't specify the governing law, and I think that's the reason for that. So then we turn to the law governing the financing agreements. So when the institution is making a loan to or equity investment in or issuing a guarantee in favor of a third party, then the core contract regulating the relationship is referred to as a financing agreement. So let's look then at the law governing financing agreements. And here there is some dependency on the legal status of the counterparty. So in the case of sovereign agreements, where the international financial institution is making a loan to a member, or where the IFI is receiving a guarantee from a member in relation to a loan made to a non-member, then the law that governs is public international law. So this is a necessary implication in the case of IBRD agreements, with the general conditions applicable to such financing, providing that the obligations of the counterparties shall be honoured, notwithstanding any local law to the contrary. So that's the phrase that's used in the general conditions at the IBRD, that if there is a dispute between the parties, then the rules all set out in the financing agreement, they all need to be applied, notwithstanding any law to the contrary. And the idea there was that domestic law ought not to be applied, and indeed it's a formula for drawing in public international law. So this provision, these general conditions of the IBRD in respect of governing law and dispute resolution, these have not changed since the general conditions were first adopted in the very early part of the IBRD's history. Now, at that time, public international law hadn't evolved to the point it has today. And at that time, there was still some uncertainty about the nature of the powers of IFIs. It wasn't clear that IFIs had the capacity to enter into treaties. And it wasn't clear whether it would be possible for a party that does have the power to enter into treaties and a party that may not have that power, whether they could choose as a governing law, public international law, a law that historically was the law that was applied only between states. So when those general conditions were put in place at the IBRD, there just was not the certainty about the law, and there was not really the confidence of the institution to assert a view of that law which ultimately may not have been upheld. So this formula was settled upon. So a member which borrows from the IBRD agrees through the general conditions that it will respect whatever is set out in the loan agreement, and that it will not invoke any domestic law that it has in order to avoid its obligations. So that's why that formula was used at the IBRD. And it's quite a powerful formula because it's been repeated in the equivalent of general conditions at the other institutions since. However, the other institutions, which were established later, of course, in the IBRD, they are more specific in identifying the applicable law. And they were able to do that because by the time they came to specify the law, there was much more certainty in public international law, and the institutions could have much more confidence about stating what the law is. And therefore, you will see in the most recent example of a large IFI, the AIIB, the governing law in the general conditions provide that the agreement, the financing agreement between the AIIB and the member is governed by public international law. So it's stated expressly. And then the provisions and the general conditions go on to specify the content of public international law. And the content of public international law is drawn very heavily from the statute of the International Court of Justice. So if you look at the sources of international law in the statute of the International Court of Justice set out in the UN Charter, then those sources are essentially borrowed and very slightly modified as the content of the applicable law for the AIIB in relation to its sovereign lending. So that's an approach that was also followed at the EBRD, and it is an approach, I believe, followed also by the Asian Development Bank, even though they may or may not specify the content of public international law. I would need to check that again. So that's sort of the easy case, as it were. So a more difficult case is, what is the applicable law in relation to sub-sovereign agreements? So if there is a financing agreement between the international financial institution and a sub-sovereign that is supported by a sovereign guarantee, then what is the governing law of the sub-sovereign agreement? So take, for example, an international financial institution which is financing a transport project in a member, and the particular project involves the development of the railway, and the institution is financing an electrification of the railway. And it turns out that the railway company is, or the railway body is a separately incorporated body. So if that is the case, then the classic way of financing would be for the IFI to make a loan to the railway corporation and to get a guarantee from the state. If, however, the railway body does not have independent legal personality, then typically what happens is that the international financial institution lends directly to the state, with the state then on lending to the railway department or this railway body. But in many instances, the IFI is lending directly to the sub-sovereign. And this is not without its conceptual difficulties, because as you know, sub-sovereigns, unlike members, do not have treaty-making capacity. So it's not possible for a railway corporation to enter into a treaty. Now, in the case of the IBRD, the former General Counsel, Aaron Brockes, had to wrestle with this question. And he argued in the 1950s in a series of lectures delivered at the Hague Academy of Private International Law that those agreements, the sub-sovereign agreements with the state, they are special, and in his words, they, quote, partake of the international character. That is to say, that they are not governed either by international law or national law. So they cannot be governed by public international law because they weren't a treaty. That was the view in the 1950s. And equally, they did not want them to be governed by any national law because there's a series of practical problems that arise from that. So this approach, I think, was a very commendable and insightful one for its time. But of course, it's been criticized subsequently because it leaves these agreements in a kind of legal no man's land. So the more modern approach, which is adopted by the more recent IFIs, including the AIB, is to expressly apply public international law as being the law applicable to those agreements, and with the content of that law being the same as it is in relation to loans to members, as I mentioned before. Now, this is possible today, unlike in Brockes' time, because it is now generally accepted that public international law may be chosen by parties that are not subjects under international law as the law to govern their contracts. So that's quite a lot to take in. Maybe I can sort of summarize all of that, again, with reference to the railway company. So if an IFI is lending to the state, and the state is using the funds to support the development of the railway, then the loan agreement between the IFI and the state clearly has treaty status, because both of the institutions, both the IFI and the host state, both have the capacity to enter into treaties. And clearly, treaties are governed by public international law, as we know. So that's the easy case. But when a loan is being made directly to the railway company, then that railway company does not have the power to enter into treaties. Okay. So in the early days of the IBRD, it just wasn't clear what the status of those agreements were. And it was understood at that time that the railway company can't enter into any contract that's governed by public international law. But today, our understanding of public international law has improved and international law has evolved. So now everyone is comfortable with the idea that parties that are not subjects of international law nonetheless can choose to have international law govern their contracts, even though that doesn't make those contracts a treaty. There's a very practical reason behind all of this, and that is that the international financial institutions are anxious that the legal agreements are not governed by a domestic law. And the problem for the IFIs with the domestic law is several-fold, but a very immediate one is that domestic law usually will regulate procurement in a manner which is unacceptable to the international financial institution. So in the railway company, the international financial institution will want to make sure that the equipment for the electrification of the line, the railway line, that's going to be obtained from reliable sources at a competitive price, and that the services for the installation of this equipment is going to be procured similarly. And this implies that there is open competition. So it'll be very often the case that this open competition will arise in a supplier or contractor being chosen which is a national of a country other than the host country. So whereas in the country that is hosting the railway project, the procurement laws will normally provide for some kind of domestic preference. So it may say, for example, that major public works shall be procured locally to some regulated extent. Or you can imagine ahead of an election that it may not be very popular to say that a new infrastructure project is going to generate lots of jobs, but in fact, many of them may be for non-voters. And so the temptation is to promise voters that a lot of the jobs will be given to them. So the international organization doesn't want to do that, because anything short of an open competition means that, first of all, there is much greater risk of impropriety of one sort or another, particularly corruption. And there is also a real risk that the goods and services that are being selected may not be the most suitable or the best for the project, and it may be that they're not the most competitively priced. So the international financial institution is keen not to have these domestic rules apply, and these domestic rules will apply from one country to the next across the world. So it'll be very difficult to keep on top of all of these rules anyway, and to supervise the implementation of the procurement arrangements. And so what the international financial institutions try and do, and do, is to impose their own procurement rules. And their own procurement rules will provide for open competition as a rule. There are some exceptions to that, but that will be the basic rule. Actually, when you're negotiating these deals with new borrowers, sometimes new countries that haven't borrowed before, or countries that haven't borrowed for a long time and now are coming back, or with the personnel who constitute the negotiating team when they're not that experienced. Sometimes you have the sense in the negotiations that the borrower is just a little bit too anxious to receive the borrowings, and you can have your doubts about how those funds are going to be used, because you have the sense that they may have some ideas that are inconsistent with what the IFI expects. And this, in my experience, can be resolved usually quite easily by explaining to the people across the table that they've received very many documents explaining the procurement processes, explaining the disbursement processes. But all they really need to remember is that when the borrower signs the loan agreement to support this railway project, they will not choose the contractors and suppliers themselves. They will not be able to do that. Many of these big, thick documents that are being handed over are designed to make sure that there is open procurement. So the borrower will not get to choose the suppliers and contractors itself. And secondly, those suppliers and contractors will not be receiving their payment from the railway company. So the institution is not dispersing the funds to the railway company that then disperses it to the contractors and suppliers. Rather, the international financial institution will be dispersing directly to the contractors and suppliers. So you can see how through this process, the possibilities of corruption are greatly minimized. And in addition, what is greatly enhanced is the prospects of acquiring goods and services of an appropriately high quality and competitively priced. And in addition, there is great efficiency in dispersing the funds because the institution is dispersing directly to the contractors and suppliers. So that's very important for the contractor and supplier community, because when an international financial institution finances this railway project, for example, in a country that is, say, not very politically stable or where the government is known for being highly corrupt, then contractors and suppliers do not want to rely on the government to have their payments made on time. But they will rely on the international financial institutions because they will have a credibility that and a great deal at stake to ensure that they do pay the contractors and suppliers on time. So having the ability of the IFI to impose its own procurement rules on a borrower and displacing the borrower's own procurement rules, that is very important in order to accomplish effective and efficient procurement. So this is why it's so important. One of the reasons why it's so important to have public international law apply to these agreements between both sovereigns and sub-sovereigns where there is a sovereign guarantee. So that's sort of like the easy case. And the more difficult one is where the loans are being made to the railway company. So the railway company is incorporated under its domestic law, and it has to comply with the law. And so it cannot opt out of that obligation. We don't have a choice of choosing which applicable laws we will honor and which we will not. So if the law applies to you, you have to comply with it. If the law applies to you, you have to comply with it. So for the railway company, then it is obliged to follow its own law. But for the IFI, it will not want that to happen because of all the problems that I mentioned before. So the way that this was resolved by the IBRD in its earliest days is that sub-sovereign agreement was given some very special treatment in order so that it would partake of the international character, which was the phrase of Brockus. And so, for example, the sub-sovereign agreement and the sovereign agreement were signed at the same time. So the loan agreement to the railway company and the guarantee from the host state to the IBRD would all be signed as a package at the same time. And then, as you know, the specialized agencies of the UN are able to register treaties to which they are party. So the IBRD would register not only the agreement with the sovereign, but it would register as an annex to that the agreement with the sub-sovereign. And those agreements were also signed at the same time in the same ceremony and then registered all at the same time. So they're all presented as though they were an indivisible package. And that was the way in which these sub-sovereign agreements were brought out of domestic law, but were not expressly stated as being governed by public international law, but by the railway company promising that in the contract that it would honor all its obligations, including to follow the procurement rules of the IFI, and to do that notwithstanding any local law to the contrary. The IFI got comfort that indeed legally it would be able to impose its own IFI procurement rules. And for the railway company, it had comfort knowing that this arrangement had been endorsed by the state that regulates it and probably owns and maybe even controls it. Because the state has been involved in this whole process in the manner I described. Plus, of course, the state is also the guarantor. Now, a special feature of guarantee agreements and sovereign agreements with IFIs is that the guarantor is more than a mere surety. It's actually a primary obligor under the loan agreement. So if the loan agreement to the railway company requires that a payment be made on a particular date, if that payment has not been made, that automatically constitutes a breach of the guarantee agreement. So the member has to fix it quickly. It's not necessary to first pursue all the rights against the railway company and then finally turning to the guarantor to making whole any losses one has made. That's not how guarantee agreements work with the IFIs. The guarantee agreements are not guarantees of suretyship. The guarantor undertakes to be a primary obligor in relation to all the obligations that are set out in the loan agreement with that railway company. So in more recent times, as I said, practice and the understanding of public international law and maybe the nature of public international law have all evolved so that now, even though that loan agreement with the railway company is still not a treaty and could not be registered with the UN as a treaty, although it could appear as an annex to a treaty, nonetheless, that agreement can be governed by public international law. And the public international law would be applied and would bind that borrower, and the borrower would have to honor all of those obligations, and it would be able to do that because, again, the closeness of the association with the member and the nature of the process for the negotiating and the signing and so forth is such that the relationship between the member and the borrower are really indivisible. So you're really dealing with the government, and the government may be represented or personified by a series of individuals, typically represented across the negotiating table by the person who speaks for the railway and the person who speaks for the Minister of Finance. The railway, because they're going to have to implement this project, including all the procurement aspects that the IFI has imposed, and the Minister of Finance, because it's the Ministry of Finance that will have to make sure that funds are available to ensure that the loan can be repaid. So that's quite a lot, I know, but it's important because it's one of the features of IFI financing. And that's something that we will talk about at a later lecture, but we've dealt with this particular issue now, and it's important because it's all to do with governing law, of course. So that's the agreements with sovereigns and sub-sovereigns where there is a sovereign guarantee. And the next case is in relation to private sector agreements. So if there's an agreement between the international financial institution and a private company, or indeed if there is a financing agreement between the international financial institution and a sub-sovereign, but there is no sovereign guarantee, then in those instances, these projects are all viewed as being private sector projects for the purposes of determining governing law. And the governing law at the international financial institutions that deal with financing in the private sector, they typically have these loan agreements governed by English law or sometimes by New York law. And the project agreements may be governed by any number of local laws, and is usually one that's selected by the sponsor of the projects. And then there are also, in the private sector projects, there are also security agreements. And these tend to be governed by the law of the place where the asset being secured is located. So again, quite a lot to take in there. So let me try and demonstrate this with an example. Suppose that a country that's very poor and not very developed and has weak infrastructure and not very strong governance, suppose that one of the attractions that the country has to offer, nonetheless, to foreign investors is that it can provide very cheap labor. So that's its competitive advantage. And as we know, in the history of development, it's often one of the ways which very poor countries have got themselves up onto the ladder of development by playing to that competitive advantage. So let's say you have a foreign sponsor and it manufactures something that manufactures shoes, and there's a lot of labor in putting the shoes together. So it would maybe move one of its shoe manufacturing plants to this to one of the least developed countries. So if it does that, then it probably has prepared everything in terms of the financing structures and the corporate structures and so forth long before it's come to the international financial institution to seek financing. So when it comes to the international financial institution and says, you know, I really need to borrow some money to make this enterprise work because my normal bank at home won't finance a project in this country, that's too risky. And there are no domestic sources of financing in that domestic country. So this is why they're coming to the international financial institution for money. And the foreign sponsor has probably established a local subsidiary in the poor country, country X. And in country X, there's a corporate law that enables the establishment of such a corporation. And the corporate law also authorizes companies to do certain things, not only to manufacture shoes, probably not specifically, but by implication, but it probably also enables them to borrow money as well, and maybe to borrow money from abroad. Maybe all these things are regulated, maybe in the company's law, maybe in other laws as well. So the foreign sponsor would create this subsidiary. Maybe there'll be a domestic investor as well, maybe someone who knows something about shoe production. And the loan that is then provided by the IFI is made to the company incorporated in country X. And then there is probably a guarantee there's probably some kind of guarantee agreement with the sponsor, between the IFI and the sponsor, the foreign sponsor. In some cases, it's like a normal guarantee, but usually for an international financial institution investing in the private sector, they will not demand such a guarantee. They will usually require a limited guarantee, typically a guarantee that the foreign sponsor will ensure that the plant that is being built to produce the shoes will be completed. Because there's nothing, you know, what are you going to do if you are a foreign lender and you have security over a half-completed shoe manufacturing plant? Not very valuable, particularly if it's in a difficult country. So you look to the sponsor to ensure that the project will be completed, and you will relieve it of its obligations if the reason it can't complete it can't complete the plant, if it's because of, say, some political factors, if the government is harassing the sponsor, or if there are all these very new and onerous taxes that are targeted very much at this particular project, or if there's a war or insurrection, things like that. You're going to relieve the guarantor of its obligations, and that's the kind of risk that the IFI will take on itself. They're really set up to take on what are very often political risks. And then again, in this example that we're looking at, there would be some security that would be provided. There'd be security over some of the physical assets. There'll be some security over the current assets, over the accounts receivable. Maybe there's a bank account somewhere. So all of these things can provide security. So you have this whole host of agreements that make up this private sector project. And then when you look at the governing law, then typically you would have English law govern the financing agreement between the international financial institution and the borrower company established in country X. You would probably have English law govern that guarantee agreement as well with the sponsor. The agreement to develop shoes, maybe there's an off-take agreement, maybe the foreign sponsor has agreed that it will purchase so many of these shoes that are manufactured. So an agreement like that will probably be governed by the law that the sponsor is most comfortable with. So if that sponsor is from Japan, it's probably Japanese law. And then the security will be, if it's physical security, it will be governed by the law where the security is located. So the assets in the plant, if they're provided for us, if they're offered as security, then it'll be the law of country X that provides the governing law. So a whole labyrinth of arrangements, but the one to focus on is really the financing agreement between the IFI and the borrower, so the loan agreement. So as I said, this will usually be governed by English law. Quite often, especially for North American transactions, quite often for agreements where the IFC is very involved, then New York law would also be a chosen law. And the differences between New York law and English law in project financing is not very material. There are some differences, but in the main, New York law and English law are very similar in relation to project financing. And the reason that those laws are chosen are several-fold. The first is that there is a tradition of these laws being applied. So it's not like there's something unusual or something suspect or something unknown that is being proposed. There's a long tradition of this happening. Secondly, the tradition exists for a reason, namely that English law and New York law are very well established. They're very well developed. They accommodate all the interests, particularly of a creditor. So creditors therefore like to choose these laws to govern their credit agreements. Another reason is that the law is one that is both steady, certain, and not prone to radical overnight changes, but at the same time, it's flexible enough to be able to provide a legal solution for a problem that may be new and not contemplated. So if there is English law or New York law governing the loan agreement, then the lenders, the IFIs, can have great confidence that English law or New York law will support the obligations that the parties freely enter into. And they will also have the confidence of knowing that if there is some unusual situation that has arisen, which they've not factored into in terms of how the law might impact on a factual situation, then they know that English law or New York law will be flexible and robust enough to be able to accommodate that. And then the final reason for choosing English law or New York law in these private sector agreements is that this is a law that is very much liked by international banks or banks operating internationally. And so if in the SHUF project in country X that we discussed, probably no commercial bank is going to lend in that country for that kind of project. But they might be prepared to lend through the international financial institution as part of a syndication. So syndicate banks will very often insist on English law or New York law. So if an IFI is financing an agreement with the shoe manufacturer in country X, and if it then wants to sell down part of its loan, then the prospective borrower, an international commercial bank, will want to see that there is a governing law with which it is familiar and with which it is confident. And English law and New York law will often do that. Now, it doesn't mean to say that no other laws are ever adopted, but these are by far and away the most common laws in international financing. It might be that a different law is chosen, which is perfectly adequate, but is not so well known, but which is nonetheless chosen because all the key players are familiar with that law. So if you have a French bank or a Japanese bank taking a very large stake in a company, in a project, then it may be that it'll be French law or Japanese law that will apply because the French bank and the Japanese bank are familiar with that law. They know what the limitations are, if any, and they know what the value is, and they're comfortable with doing that. If there is to be a syndicate of such banks, and it's no longer just French or Japanese banks, but it's going to be banks from all over the world, then chances are that those other banks collectively will press to have English law or New York law govern, because it's just more widely used and sort of more widely known. So that's all I really wanted to say about governing law in relation to the financing agreements that IFIs enter into. So it's a big subject, and it also eats into a little bit of the next lecture that we're going to have, but I think it's worth covering in the manner in which we have, and to have done that now. So then moving to dispute resolution. So we know what the law is that is applied. So if there is a dispute, how will this be resolved? Now, in the case of the procurement contracts, our example of the purchasing of the stationery, then usually this will be resolved by local arbitration. So the IFIs will not want to be drawn into any court process if they can avoid it, for a whole host of reasons that I'll expand on in a moment. So if they can arbitrate, then that's what they will do. And the arbitration can often be quite light, and it could be quite local. Maybe it won't be as extensive as it would be relative to the dispute resolution that would apply for international financings. Now, in the case of employment disputes, these are resolved by putting into motion the review mechanisms that the institution has, including its administrative tribunals. And the administrative tribunals are usually those of the institution itself. So there's the World Bank Administrative Tribunal, there's the Asian Development Bank Administrative Tribunal, there's the Inter-American Development Bank Administrative Tribunal, and so forth. Or it could be that they don't have their own tribunal, but they use the tribunal that is provided by the International Labour Organization. And the International Labour Organization Administrative Tribunal is one that can trace its heritage back to the League of Nations. So it's been around for a long time. Or it might be that, especially in the case of a specialized agency of the UN, it may choose to make use of the administrative tribunal offered by the United Nations. So that's procurement contracts and employment disputes. So then coming back to the financing agreements. So we talked about the sovereign agreements, that's public international law that's going to be applied to those. And this will not be applied by a court, but there will be arbitration. So in the case of the examples that we gave before about the railway company, then if there is a dispute, it would be resolved in arbitration, and it would all happen at the same time, most likely. So there is probably never any genuine dispute. There's usually just a payment failure. And so because of that, there's often no point in pursuing any kind of process. And indeed, in the history of the IBRD, there has never been an arbitration, or at least not an arbitration that is run all the way through to becoming a published award. And the reason for that is that if there is a payment failure, it's probably just because the state is struggling to make the payment, not because it's disputing the obligation to make the payment. But nonetheless, there is this process that's provided for this, and this arbitration. It's an ad hoc arbitration. There are very elaborate procedural rules that are set out by the IBRD, and that was all done very early on in the life of the World Bank, and that was done then because at that time the content and structures of dispute resolution had not evolved to the point where they are today. And so for the newer institutions such as the AIIB and even for the EBRD, then there was no need to prescribe elaborate procedural rules to cover an arbitration. Instead, they just adopted the United Nations rules. The United Nations Commission on International Trade Law has some rules, and these are perfectly adequate for it and are designed for ad hoc arbitration. So the EBRD and the AIIB do have this ad hoc arbitration adopting UNCITRAL rules, and rather than having an elaborate process for appointment, they just choose an appointing authority. In the case of the AIIB, and I believe as well the EBRD, it's the Permanent Court of Arbitration in The Hague. And The Hague is also specified as being the place of arbitration in the case of the AIIB and the EBRD. It's an interesting discussion about how you choose the place of arbitration. If there are questions on that, I'm happy to answer them. But for the IBRD, in its dispute resolution provision, no place is specified. So if one was crafting a clause today afresh, one would not do what the IBRD did then. However, the IBRD clause has never been changed because I think there is a reluctance to meddle with a provision which in fact has never been used to date and which could in fact be quite difficult to renegotiate with the membership. So that is also true. What I said in relation to sovereign agreements also applies for the sub-sovereign agreements where there is a sovereign guarantee. Now, in the case of private sector agreements, the English law or New York law, or maybe even the French or Japanese law applying, then the disputes will also typically be resolved by arbitration. So the international financial institution will often impose, or which will negotiate rather, arbitration as the preferred means of resolving disputes, but it will often have a unilateral right to litigate. So this doesn't work for all countries. For example, in Russia and Turkey, you cannot have a unilateral right to litigate. But the arbitration that does take place, it's usually institutional rather than being ad hoc. And the UNCITRAL rules are usually specified. There's an appointing authority, and the place of arbitration is usually specified. So again, quite a lot to take in, but I would say for the private sector disputes, for the international financial institution, arbitration is the preferred means of resolving them because the IFIs do not want to get drawn into the domestic courts. And the reasons for that are several-fold. The first is it becomes a very difficult business to manage if potentially you have to either pursue claims or defend claims in many different courts in many different jurisdictions across the world. And that would be particularly the case with, say, the IFC, which must have the largest number of countries where any IFI actually invests. So it'd just be very inefficient to be defending or pursuing proceedings all over the world. But of course, the institution recognizes and seeks to be held accountable for its own actions. So if, for example, if it just refuses to disperse, then it needs to be held accountable for that. So another reason why the IFI will not want to be drawn into the domestic courts is that the institution has privileges and immunities, which on the whole enable them to avoid being drawn into domestic courts. We saw that this varies from institution to institution, but certainly in the case of the AIIB, this jurisdictional immunity is quite extensive. Of course, it doesn't apply in countries that are not members, such as Japan or such as the US. But where there is jurisdictional immunity, generally the institution will want to take advantage of that. Then also, if there are genuine disputes, then it's often preferable to have these resolved in arbitration anyway. It's a private means of resolving the disputes, and you don't have the public reviewing every aspect of the process. And you can choose all the rules. So you can choose the language that you want the proceedings conducted in. Whereas if you get caught up in a court proceeding in a third country, it may be a language with which you're unfamiliar. The court process may be unfamiliar. There may be many layers of appeal. Matters may go on for a long time. There may be issues to do with judicial corruption. So for all of these reasons, arbitration may be preferable. However, often there is no genuine dispute, there's just a payment failure. And in those instances, the international financial institutions will often want to reserve to themselves the right to be able to initiate litigation. So these so-called split clauses are quite common. And it doesn't mean that if an arbitration is going badly, that the IFI can then decide that they want to litigate instead and have two bites of the cherry. It doesn't mean that. It means that before any step is taken, the IFI can decide whether to initiate an arbitration or a litigation. And sometimes the litigation is desirable because in some jurisdictions, if there is no genuine dispute and there is just a payment failure, it may be quite easy to get a judgment from a court, and then the judgment may be able to be enforced quite quickly. An advantage of arbitral awards is that it's, generally speaking, much easier to enforce an arbitral award than a foreign judgment. But there will be instances where an ability to pursue court proceedings will be more attractive to the IFI. So looking at our shoe example in country X, suppose things just go very badly and the sponsor has misjudged the market and the shoes fall out of fashion and it just turns out not to be an economic enterprise and the borrower just doesn't repay the loan, doesn't make the loan payments on time, and the judgment is reached, the view is reached that it's hopeless, that they're never going to be. And so the IFI probably won't be the only creditor. There'll be many of them. It may be necessary to prove a claim in a domestic court by having a judgment from that court. So if that's the case, then the IFI may want to go to the court to seek a judgment so it can then submit that in the bankruptcy proceedings and then hope that it can receive some of the assets that are going to be paid out in the bankruptcy. Or it might be that it's in fact the only creditor, but there is a bank account somewhere. Let's say this shoe company had a UK or a New York sponsor, and there's a bank account in London or in New York. Then if you have a foreign judgment, then you may be able to attach the proceeds of the bank account in London or the UK. So sometimes there may be some value in being able to seek a judgment. So this is why the IFIs try to do that. But in some jurisdictions, and I gave you two examples, I know that in Russia and Turkey, from my own experience, at least it was the case, and I believe it still is the case, you can't have these split clauses because the judicial view is that it's important to have sort of an equality of treatment to both parties. So it's fine for both of them to be able to arbitrate, but you can't have just one of them being able to initiate litigation. Now, the counter-argument to that, of course, is that, well, the whole thing is one package. You know, you don't have to borrow from the institution, but if you do, then this is the package that you get. And besides, it's not that conceptually consistent to insist on equality of treatment, because the courts of those same countries do not see a problem in a lender being able to choose which among several court jurisdictions it can enforce its claim in. It could be its home country, it could be the country of the borrower. But for the borrower is only usually able to pursue its claim where the creditor is located. So there's already an inequality of treatment there, as it were. But nonetheless, the general rule is that these split clauses are popular. They seem to work in more developed jurisdictions, at least, and I think they will remain a feature of international project financing for some time. So that's all I wanted to say about governing law and dispute resolution. And this is all relevant because it is contracts that are at the heart of the relationship between the IFI and the external stakeholders that we have looked at so far. But there are also some other stakeholders where the relationship is not marked by contract. And in particular, we have third parties. So the legal relationship between IFIs and third parties is only rarely one of contract. An exception might arise where a contract may be implied But even where there is no contractual relationship, international organizations may still be liable for injury they cause a third party. The principle that an international organization may be held accountable for its actions is now generally accepted as part of customary international law. This is as true for international financial institutions as it is for international organizations generally. Now, this is a complex area of the law, and it led the International Law Commission, which, as you know, works within the aegis of the United Nations, to adopt draft articles on the responsibility of international organizations some 10 years ago. But these have proven to be somewhat controversial. They've not yet gained broad acceptance, and maybe they never will. The main complaint is that these articles are modeled on those that relate to the responsibility of states. And the critics argue that states are just so fundamentally different from international organizations. States have really an unlimited ability to undertake whatever actions are in the interests of the state, subject to external constraints. But in the case of an international organization, they are the creature of those members, the member states, and they can only do the very limited things that they've been empowered to do by their members. And therefore, carrying over the articles applicable to states to international organizations, the critics say, is unhelpful. And then finally, in relation to external stakeholders, we may consider the area of regulation. So because IFIs are not the creation of any national law, they're not governed by any national law. Rather, they are created by public international law and governed by public international law. So within the constraints of that law, the IFIs are self-regulating. Rules are made by the various governance bodies, and these constitute the internal legal order. So you've seen the email containing the link to the AIIB website page where the role of law at the institution is discussed. So the institutions, they regulate themselves. It's actually one of the fun parts of working at an international organization, is that you also, as a lawyer, you get to do many more things than you would do anywhere else. So because like everywhere else, you have to determine what the law is and then to give advice on it. But at an international financial institution, the law that you are generally advising on is the law that's been developed within the institution itself. And if you find that there is a gap in that law, or that the law really is flawed, then it's open to you to take a step to promote the review and reform of that internal law. Of course, in theory, you can do that everywhere, but an international financial institution, you have real influence over that happening. So if there's a gap in the internal rules regulating any aspect of the institution's activity, then you can propose a correction of that. So as a lawyer, not only do you have to find the law, you have to interpret it, and you can have a role in the reform of that internal law as well. So it means working at an IFI can be quite attractive from that perspective for a lawyer. So it's the internal laws that are important. This is the regulation that an IFI has to look at. So the regulations that are issued by third parties do not directly apply to international financial institutions because they are not subject to the jurisdiction of any national regulator. However, the regulation of third parties may be relevant to IFIs because they inform the policies that those institutions adopt. For example, IFIs typically demand that certain environmental and social standards be respected in the design and implementation of the projects they finance. And these often include, say, certain labor standards set by the International Labour Organization, or they provide for the avoidance of certain environmental substances which have been judged as damaging by different international conventions. So the international financial institutions, they don't operate in a vacuum. They may not be regulated by others, but they listen to what some of those regulators have to say, and they may internalize within their own internal regulations some of what the external regulators are saying. So that brings us to the end of our session on external stakeholders. So do we have any questions there? Any comments that anybody would like to raise? Let me just pause for a minute or two and enable people to reflect on that before we move on. So in this part of the lecture, we're going to move to the funding of multilateral financial institutions. So first of all, what is the need for funding? So in order to pursue their objectives, international financial institutions need funds. Now, this is true for all international organizations, but it is especially the case with IFIs, which are in the business of financing development, using their own funds or mobilizing the funds of others, all in pursuit of the IFI objective, which, as we noted earlier, is always a dimension of development. Funds are needed most immediately to support the administrative and capital budgets of the secretariats of the IFIs, without which the institutions cannot operate. Large administrative and capital costs typical of IFIs include housing the headquarters and other offices, the costs of staff and consultants, travel expenses, and the like. The proportion that these costs constitute of the overall administrative and capital budget varies from one institution to another, depending on the circumstances. For example, in some institutions, premises are provided by the host country. This is the case at IFAD and at AIIB. So both IFAD and AIIB have wonderful headquarters buildings, and these have been provided by the Italian state and the Chinese government, respectively. But at EBRD, the very beautiful headquarters in the center of London, in the city of London, those headquarters command a rent that has to be paid by the EBRD. So that makes up a material portion of its budget, unlike the case of the AIB and IFAD. So that's one circumstance that can have an impact on the overall administrative and capital budget. Another is that staff, consultancy, and travel costs can be very substantial. And at AIB, these constitute the bulk of the administrative costs of the institution, staff, consultancy, and travel. Although, of course, travel costs have gone down a lot during the time of the pandemic. But an important consideration is whether some or all of these costs can be recovered. For instance, when an IFI is administering a special fund or trust funds, the costs of doing so, including the costs of the personnel involved, are borne by the contributors. In the case of special funds, first introduced by the Charter of the Asian Development Bank and extensively used by EBRD and increasingly by AIIB, the costs of administering those funds may not be charged to the ordinary capital resources. So the ordinary capital resources are funding the staff costs of the institution. But if the staff are working on a special fund, then their costs have to be absorbed by the special fund. Now, a further example of staff and consultancy contracts being recoverable is where, in the case of project financing, in the classic sense, for example, the shoe factory in country X that we discussed, there the sponsor of the project agrees through a mandate letter to meet the costs of the institution incurred in undertaking due diligence, including travel costs to the project site and to the place of negotiations, and preparing and agreeing the financing agreements. So in the shoe factory example, what would typically happen is an international financial institution, once it is made a decision to look at a project proposal seriously, it will ask the sponsor to sign a document called a mandate letter, whereby all of the costs of the IFI are agreed to be met by the sponsor. These mandate letters can be quite elaborate, and sometimes they can provide for fees to be paid as the project moves through different cycles of approval at the institution. But the key point for now is that these staff costs, the travel costs, and so forth, if they're related to a project financing in the private sector, then in the main, these ought to be met by the project sponsor. Now, beyond the immediacy of sustaining the secretariat, IFIs need funds primarily to deliver on their operational mandate. So as their name implies, IFIs finance development. This financing may take several forms, and the availability of different financing instruments varies across institutions. The AIIB is among the most flexible of the IFIs in this regard, being able to make loans to sovereigns, to sub-sovereigns, and the private sector, and being able to invest in various forms of equity, including in funds, as well as being able to issue guarantees. And incidentally, the nature of the investment instruments may have a bearing on the source of the funding. So what are the sources of funding? How do the IFIs fund themselves and the projects that they support? So there's really two elements there. And taking these two separately, IFIs themselves are funded by a combination of shareholders' funds, paid-in capital and accumulated reserves, as well as borrowings. So when we're thinking about the sources of funds, we need to think about what are the funds that the IFIs need to sustain themselves and to finance the projects that they are financing, and also, and so where is that money coming from? But also, where is the money coming from to finance the projects that the IFIs are supporting, insofar as not all of the funds necessary for those projects will come from the IFI itself. So let's look at the first bit ourselves. So we're looking really at paid-in capital, callable capital, the accumulated reserves, and then we will also then look on at the borrowings of the institution. So looking first at paid-in capital and accumulated reserves, the starting point is to observe that the capital structure of most IFIs sets them apart from other international organizations. So typically, only a small proportion of the authorized capital of an IFI is in the form of paid-in shares, with the balance being made up of callable shares. So upon becoming a member of an IFI, both the paid-in shares and the callable shares are issued by the institution. As we learned in an earlier lecture, these shares are not negotiable. Accordingly, to acquire membership, shares must be issued by the institution. They cannot be acquired by another member. Now, the payment received by the IFI from its members for the issuance of paid-in shares represents funds that the institution may use for its general purposes. In institutions that invest in the private sector, IFI investment in the equity of corporations and funds is usually funded from the equity of the institution. So paid-in capital delivers cash to the institution, and callable capital provides the potential for the delivery of cash, theoretically, but the reality is that callable capital ought not ever to be called, and indeed there has been no call on callable capital in the history of the IFIs. And this is because such an event would only occur if the IFI was unable to pay its debts from all other sources. So callable capital can only be used in those circumstances. However, callable capital is very valuable because its existence provides additional comfort to creditors, including bondholders, and enhances the creditworthiness of the IFI. As we have learned in an earlier lecture, capital in IFIs is allocated primarily on the basis of the economic strength of the members. Therefore, the bulk of the callable capital is held by members with the most economic strength, and the assumption is the capacity to make good on a call. The existence of callable capital and the creditworthiness of the largest holders of that capital are important considerations for rating agencies when assigning IFI credit ratings. And finally today, I'd like to mention accumulated reserves. So although the purpose of IFIs, unlike private sector corporations, is not to maximize the wealth of their shareholders, nonetheless, IFIs do seek to be profitable. This is important in order to remain financially sustainable and to avoid any risk of the callable capital being called. Where profits are made, these will accumulate in the reserves unless a dividend is paid, something which we have already noted is provided for in the charters of the IFIs, but appears never to have been used, although it has been discussed from time to time. Reserves can also be capitalized, as happens occasionally, so that the paid-in shares of the members increases. Or the reserves can be depleted by making payments for other purposes, quote unquote, such as replenishing IDA in the case of the IBRD, or replenishing special funds, as has happened at the EBRD. But for so long as reserves are in place, this enhances the capacity of the institution to invest, because prudential lending limitations are usually a function of shareholder funds. And the accumulated reserves also bolsters the creditworthiness of the institutions. So let me stop there, and at our next lecture, we can look at the other means by which IFIs fund themselves, beginning with borrowings, but also looking at special fund resources and grant funds, and how they mobilize co-financing, including through the use of the A-B loan mechanism.